All right. And what about other professionals helping you with this process? Obviously, the parties would have an accountant. They may have a personal accountant. They may have a business accountant. There are investment and retirement specialists that help them and planners. There may be insurance people. There may be a whole host of other professionals that have been part of this family's team to organize their finances. How often do you approach those people for assistance, and do you find that they are cooperative when you do approach them?
Well, team is the right word. And in certain cases, especially the more complex and larger cases where there are issues of trusts that are established or going to be established, and where there are numerous corporate issues, there's certainly a team that sort of comes with the client. And I often find that the team is very helpful, and you rely on them in a few ways. They know the client for a much longer period of time than you do. Also, we may have to bring somebody in to assist that client, and that's where I bring somebody in that I've worked with, that I'm comfortable with, that I know will work well with that client, either personality match or their style and approach, or more importantly, their experience in that particular business or field. But you definitely want to include these people. When a divorce case is over, the last person the client wants to see is their divorce attorney, frankly. And they're going to keep their insurance person, they're going to keep their financial planner, they're going to keep their accountant. So you want to make sure they have the right team behind them.
From your experience, do you find that there's a common thread to the misrepresentations that may be made by one party to another?
Well, when you say common thread, what do you mean by common thread?
Well, do both spouses really know how much money one earns, or what they spend, or where the money comes from, or what assets they may have, whether it be a bank account or the value of a business?
I think they do, and I think it's my obligation as an attorney representing someone who doesn't have the knowledge to make sure that, number one, I have the knowledge and that I sort of teach them that knowledge so they understand. Or if it's too complex, which it is for a lot of people, bring in the right professional who's going to help explain to them or explain to me in some cases. In many cases where I'm not familiar with a certain type of business and how it operates, I'm going to bring in somebody like you, for example, to tell me what the business does, how they work, how they operate, why it looks like they're losing a ton of money on paper, but yet these people are living a certain lifestyle, which definitely doesn't indicate they're losing any money. So you need to have more than a general understanding. And in Connecticut, and I can compare Connecticut and New York from my experience in both, before divorce can be finalized, both parties go to court, and a judge reads the agreement and has to approve that agreement. And a judge is going to ask both parties questions about that agreement, some of the terms of the agreement, and specifically whether they understand the terms, whether they have any questions, and whether they think if there are children involved, it's in the children's best interest. So they're going to make sure no one forced them to enter into the agreement. They're going to do sort of their due diligence to make sure it's fair under the circumstances.
You know, to compare New York to Connecticut, I think is a good tool. In New York, when a couple gets divorced, each party prepares what's called a net worth statement, and then that net worth statement is certified by the attorney and submitted to the court. And in Connecticut, we call it a financial affidavit.
That's right.
And it serves basically the same purpose. It identifies the assets, it identifies the liabilities, and it comes up by subtracting the two. It determines the net amount, or the net assets, or the net deficit of the couple. Are there other similarities between getting divorced in New York as compared to Connecticut? And after you identify the similarities, maybe you can tell us some of the differences.
There are far more differences than similarities, I should say. First of all, in Connecticut, it's a no-fault state. So you can just wake up one morning and say, I want to get divorced, and file for divorce, so long as you meet the residential requirements. In New York, you have to prove that one spouse was at fault. For example, adultery, that one spouse was having an affair with somebody else. You have to have proof of that. If you don't, and you want to get divorced because you're not getting along in New York, you can't. You need grounds. You need to prove maybe cruel and inhuman treatment, which is not an easy standard to prove unless you've spent a lot of time having the police involved in your life. In Connecticut, again, it's just the marriage is broken down and we want to get divorced. There are some cases where New Yorkers move to Connecticut so they can file for divorce. New York, the day you file the divorce action is the day that the assets stop accumulating as marital assets. And there's something called separate property. Anything earned thereafter in New York can be considered that party's separate property. In Connecticut, The assets are valued as of the date of the divorce. So you want to hope that you continue to make a lot of money and the assets keep growing, because if they do, you're going to split the pot at the end of the rainbow, not based on where it is at the beginning. Those are two of the biggest differences. To add a few wrinkles, and I use this hypothetical with clients a lot, in New York, if the day after the marriage, the husband got $1 million inheritance and he left it in a bank account and now it was worth $2 million 10 years later, and they had no money between them, and they had 5 kids, the husband would get all $2 million because he didn't commingle it and it's separate property. In Connecticut, if you had the same facts, that inheritance could be split 50-50, for example. In fact, if there were 5 kids, it probably would be. The longer the marriage and the longer the inheritance has been part of the marriage, the more likely it'll be treated closer to 50-50. That's a general rule, but inheritances are marital property in Connecticut. They're not in New York.
That's very interesting. What about the approach to, for instance, valuing a portfolio? Do they include an allowance for income taxes based upon a hypothetical sale? And if they don't, is there any other modification that the court may address to try to even the playing field when it comes to splitting that asset?
Well, one thing a court will do, and you got to realize these judges have so many cases and so much going on, that when it's time to make a decision, what they want to do is do something, frankly, quick and easy. And I'm not disparaging the judges by saying it's not creative, but the advantage of settling a case is you can be more creative. So when it comes to dividing a brokerage account that might have $200,000 in stocks, the court's just going to say 50-50 in kind. And that's what's going to happen with the account. What the court could do, though, is they could consider that there's $200,000 and give that to one spouse and just call it $200,000 and give the other $200,000 from a cash account. They don't have to take into account the capital gains taxes, for example, on that $200,000 account.
Is there any time you have declined an engagement because the client was not able to provide you with documents, or the information that you obtained from your client was not reliable and you didn't want to hang your hat on it?
Unfortunately, yeah, it does happen. We sort of have a rule in our office that documents, information have to be provided by a certain day. And if they're not, we know what the other side's going to do. They're going to file certain motions with the court. And I would like to think that I don't go to court too often where I haven't, or my client hasn't complied with the request. If there's information that needs to be produced, they're going to produce it. And if you have a problem with a client, it's not worth going out there and putting your reputation on the line, frankly, and trying to cover for somebody that's not following a basic discovery rule. When there's a client that you find to be dishonest, it depends on the level of dishonesty, obviously, but I always find that I never learn the story the first time I meet them, or the second time, or the third time. I try to tell clients I don't believe in surprises, and I hope that by the time the more I get to know a client, there aren't any. But things pop up at certain points, and you've got to let a client know. The worst is when something pops up when they're on the witness stand, and it happens sometimes. It's one of the worst feelings to be completely left defenseless in that situation. So yes, if a client doesn't really comply, they need to find other counsel.
Well, on that note, Eric, I want to thank you very much for joining us today. I think the discussion about obtaining documents and a general understanding of the divorce process is very, very helpful. Our guest today has been attorney Eric Broder. Again, Eric is a partner and founding member of Broder & Orland. If you have any questions on this topic, I'm sure that Eric will be happy to assist you. You can reach Eric in his Westport, Connecticut office. His phone number is area code 203-222-4949. As always, our audience is welcome to contact our office with any questions or comments. Stay connected to us on the web at www.msgcpa.com. We can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. Your topic suggestions for future broadcasts are always welcome. Until our next podcast, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and/or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA, PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.